The air itself seemed to tremble in the hushed federal courtroom. Sharp and final, the gavel descended as Judge Beryl Howell declared, "Congresswoman Crockett, I will not permit my courtroom to become a stage for political theater." An electric hush descended, as though the entire nation held its breath in that singular moment. Yet there she stood, unwavering as stone against a torrent, Jasmine Crockett. She held her ground. Her resolve unshaken, her gaze steady upon the bench, she spoke in a voice both pure and resonant, reminding the judge and all who listened, "Your Honor, with the utmost respect, the Constitution does not cease at your bench." This transcended a mere personal confrontation. This went beyond a simple legal dispute. This was a battle for the soul of American democracy itself, a confrontation between entrenched power and a fearless new generation determined to hold authority accountable. The Washington Federal Courthouse had stood witness to history many times before. Within its stone walls lingered the reverberations of powerful arguments, watershed rulings, and the measured footfalls of attorneys carrying the Constitution's weight. Yet on this particular day, a different energy permeated the air, one that would remain unforgettable for all present. The gallery overflowed with spectators. Reporters filled the rear benches, pens poised, devices humming with breaking updates. Side by side sat civil rights advocates, their attention fixed forward. Law students leaned in eagerly, documenting not merely the words themselves, but the very spirit of the unfolding confrontation. Presiding over the proceedings was Judge Beryl Howell, age 63. Her silver hair gleamed beneath the courtroom lights, steel-gray eyes piercing. A seasoned federal judiciary veteran, her reputation preceded her, strict, impatient with perceived showmanship, devoted to order above all. For more than 10 years, lawyers entering her domain anticipated not warmth, but rigorous discipline, swift interruptions, terse observations, and the inexorable rhythm of the clock she controlled. To countless observers, she embodied the established order, the authority inherent in judicial robes, the burden of tradition, the institution's austere countenance itself. Yet standing in direct opposition was someone cut from entirely different cloth. Jasmine Crockett, Texas Congresswoman, civil rights attorney turned lawmaker, a woman forged not within elite institutions, but through the demanding battles of grassroots legal work. At 42, she carried the passion of a generation that had witnessed injustice directly and refused silence. Her natural hair, her crisp navy suit, her composed bearing every element communicated not merely style but substance, a life defined by resilience and defiance. When these two worlds converged in that chamber, the realm of established judicial authority and the domain of resolute civil rights advocacy, the collision produced undeniable sparks. The case centered on recently enacted election laws, provisions that reduced early voting periods, limited mail ballot access, and imposed stricter identification requirements. Proponents labeled it election integrity. Opponents termed it voter suppression. For Judge Howell, this represented a legal question, statutory analysis, judicial precedent, the parameters of legislative power. For Congresswoman Crockett, it signified something profoundly greater, democracy's fundamental essence itself. As she rose to address the court, she bore not only her legal brief and research, but the accumulated burden of generations denied suffrage, silenced through technicalities, rejected at polling places. "Your Honor," she commenced, her voice unwavering, "these laws undermine our republic's foundation. They do not fortify democracy. They suffocate it." A wave of astonishment swept the gallery. Reporters wrote frantically. The judge's eyes sharpened. The conflict now stood clearly visible. Judge Howell leaned forward, slicing through the Congresswoman's statement like a blade. "This court does not accommodate political speeches. Address the law." The first interruption arrived, sharp, dismissive, calculated to establish hierarchy. Yet Crockett remained undeterred. She reorganized her documents, held the judge's stare, and continued forward, referencing precedent, invoking constitutional doctrine, presenting not simply argument, but substantiation, charts, statistics, historical framework. Once more, Howell intervened. This is a courtroom, not an academic lecture. The second interruption came louder, more forceful still. The gallery grew tense. Legal scholars murmured. Civil rights attorneys exchanged meaningful glances. They had encountered hostility previously, but this felt distinct. This resembled a mounting tempest, pressure intensifying. Still, Crockett persisted. Her language sharpened, her tone remained steady. She invoked the 14th Amendment. She referenced equal protection. She discussed the Voting Rights Act not as abstract legal theory but as an active safeguard. Then the decisive moment materialized. The gavel crashed down. The judge's voice dominated the chamber. Enough. Congresswoman Crockett. I will not permit this courtroom to transform into political theater. The ensuing silence proved deafening. Every observer leaned closer, pulses quickening, understanding the forthcoming words would determine not merely the hearing's character, but potentially the legacy of everyone assembled. Here, within this silence, Jasmine Crockett's authentic strength emerged. She drew herself taller, and her voice, measured yet immovable, penetrated the quiet. Your Honor, with complete respect, the Constitution does not conclude at your bench. With that declaration, the courthouse itself appeared to shift. The gallery gasped collectively. Reporters froze. The judge stiffened visibly. In that instant, battle lines crystallized. This had evolved beyond mere legal argumentation. This became a confrontation between authority and principle, between judicial power and conviction strength. What transpired next would generate reverberations extending far beyond those chamber walls. Crockett's defiance would not merely challenge one federal judge, it would resonate throughout the nation. The silence following her pronouncement was not vacancy. It possessed density, vitality, pulsating with tension. For a heartbeat, the atmosphere in that federal courtroom appeared suspended. Spectators pressed forward. Reporters halted mid-notation, and Judge Beryl Howell sat rigid, her gavel still gripped, as if unable to fully process what had been stated before her. Your Honor, Crockett restated, steady and composed. The Constitution does not conclude at your bench. No shouting occurred. No fury erupted. The words emerged with clarity, with reverence, with the authority of someone understanding that the principles she carried possessed greater weight than judicial robes, exceeded the gavel's power, predated the court's very existence. That was the moment the courtroom transformed. Judge Howell, accustomed to immediate deference following any rebuke, found herself confronting a woman who would not yield. Her voice rose, sharp as a blade's edge. Congresswoman, you will limit yourself to legal precedent or face contempt charges. But Crockett, unshaken, advanced. Her eyes fixed upon the bench, her shoulders set. Her voice resonated with strength derived not from position or status, but from truth itself. I am presenting precedent, Your Honor. Brown versus Board of Education, Harper versus Virginia Board of Elections, Reynolds versus Sims. Cases this court cannot disregard. Decisions where the Supreme Court determined that what some dismiss as politics constitutes constitutional law's very foundation. The gallery gasped anew. Reporters' pens raced across pages. Smartphones illuminated as live updates fired across networks. For decades, Judge Howell had dismissed attorneys with curt words. But now the courtroom's control had shifted. Crockett had claimed the floor and remained far from finished. Your Honor, she stated, her tone sharpening, her words deliberate. When you reject constitutional arguments as political rhetoric, you do not uphold the law. You diminish it. When you characterize equal protection as distraction, you do not strengthen democracy. You erode it. And when you suggest that a member of Congress, oath-bound to defend this Constitution, lacks legal understanding, you do not preserve this court's dignity. You damage it. Each statement landed with impact. The chamber's energy intensified. This space no longer functioned solely as a courtroom. It had become a platform, an educational forum, an ideological battleground, and Judge Howell, for the first time in her extensive career, found herself losing dominance. She rose from the bench, one finger extended like a weapon, her complexion flushed crimson. "Congresswoman, you will not instruct this court." But Crockett raised her hand, palm outward, resolute yet calm. "Respectfully, Your Honor, I am not instructing. I am reminding." Sharp intakes of breath erupted. A black congresswoman standing before a federal judge had just raised her hand as though to indicate, "Await your turn." The moment carried historical weight, symbolic significance, the profound current of struggle that has characterized this nation's civil rights movement. Then, with the chamber frozen once more, she delivered the statement that would reverberate far beyond those walls. Article 1 of the Constitution established the governmental branch I serve within. It created the very court upon which you now preside. We, the people's representatives, granted this judiciary its authority. And I stand here today to remind you that authority does not position you above the Constitution. It obligates you to it. The courthouse trembled with those words. They transcended mere argument. They constituted a civics reminder itself. A fundamental lesson in governmental separation of powers delivered not by an academic scholar but by a congresswoman bearing lived experiences fire within her spirit. For nearly 30 seconds, nobody stirred. This was the variety of silence only history generates, where everyone recognizes they are observing a pivotal moment. When the silence finally broke, it broke like a deluge. Reporters rushed from the gallery, fingers flying across keyboards, voices urgent into microphones. Unprecedented confrontation in federal court. Civil rights attorneys shook their heads in wonder, whispering they had witnessed nothing comparable. Students scribbled furiously, knowing they would someday recount to their grandchildren their presence there. Outside, the news spread like wildfire. Social media ignited. Within hours, millions had encountered quotations from the confrontation. By evening, television anchors replayed the words continuously. The Constitution does not conclude at your bench. Organizations responded swiftly. The ACLU lauded Crockett's defense of fundamental rights. The NAACP characterized her stand as a necessary challenge to judicial overreach. Even the American Bar Association, typically cautious, released a statement, "Constitutional arguments merit consideration." Vigorous advocacy presented professionally represents our democracy's lifeblood. Meanwhile, Judge Howell's standing began deteriorating. The Federal Judges Association received complaint waves. Legal ethicists authored opinion pieces questioning whether her interruptions and dismissive manner had violated impartiality standards. But Crockett's prominence only ascended. The recording of her address circulated through classrooms, replayed on news broadcasts, analyzed in legal blogs. Law professors termed it a masterclass in advocacy under pressure. Activists declared it a watershed moment for voting rights. And the American public, observing from living rooms and kitchen tables, recognized in her not merely a congresswoman or attorney, but a Constitution defender herself. This transcended one courtroom battle's climax. This was a spark igniting nationwide debates regarding power balance, democracy's meaning, and the courage required to speak truth to authority. But that day's consequences for Judge Howell, for Jasmine Crockett, and for American voting rights' future, had only begun unfolding. The instant the judge departed the bench and announced recess, the spell fractured. The constraining silence yielded to explosive energy. Reporters rushed into corridors, phones against ears. Civil rights attorneys whispered incredulously. Law students clutched their notes, understanding they had witnessed lessons no textbook could provide. Yet that confrontation's true significance would be measured through ripple effects extending far beyond courthouse walls. For Judge Beryl Howell, the backlash arrived immediately and severely. A woman once renowned for stern authority now found her name associated with terms like overreach, impatience, and prejudice. Over 200 complaints arrived within the initial week. The Federal Bar Association's Ethics Committee initiated a preliminary investigation. While formal sanctions seemed unlikely, the inquiry itself undermined judicial credibility. Worse for Howell was her peers' private response. Senior judges whispered she had overstepped boundaries. Her reputation, once impregnable, now bore cracks. For Jasmine Crockett, the narrative proved entirely different. She returned to Capitol Hill not diminished, but strengthened. In hearings, her voice grew sharper, her inquiries more incisive. When corporate executives evaded, she reminded them with dry precision, "I have already devoted an afternoon explaining constitutional law to a federal judge. If you believe your evasions will intimidate me, you are gravely mistaken." That line also achieved viral status. Her colleagues praised her determination. House leadership commended her publicly. Activists invited her to platforms. Law schools requested her as guest lecturer. Most importantly, ordinary citizens recognized in her a champion. Civil rights organizations seized the moment. The ACLU, the NAACP, the Southern Poverty Law Center all highlighted Crockett's confrontation as a mobilizing call. Donations surged, in certain instances quadrupling within weeks. Grassroots organizations incorporated her courtroom address into fundraising campaigns. She stood up in court. The advertisements proclaimed, "And now we must rise in our communities." The strategy succeeded. Her defiance's spark became fuel for a broader voting rights defense movement. In universities, law professors restructured their curricula. Constitutional law courses incorporated a new case study, Crockett versus Howell. Students analyzed her approach, her tone, her precision, her refusal to be provoked. Mock trial competitions began featuring scenarios modeled on the confrontation. In classrooms, professors spoke reverently. What you observed was not merely legal advocacy, it was civic education. It was democracy defended in real time. Meanwhile, everyday Americans debated the clash in living rooms and on talk radio. Some viewed Crockett as heroic, a David facing judicial authority's Goliath. Others criticized her boldness as disrespectful. Yet regardless of perspective, one fact remained undeniable. People were discussing voting rights, constitutional limitations, and judicial roles in ways they had not for years. For a public often exhausted by politics, Crockett's defiance provided a jolt of clarity. It was dramatic, certainly, but it was also civics. It reminded people the Constitution was not an artifact. It remained alive and it mattered. Within the judiciary itself, the confrontation became a quiet cautionary account. Judges discussed decorum, temperament, the dangers of underestimating those appearing before them. In judicial training programs, Crockett's words began appearing as instructional tools, reminders of the delicate line between authority and arrogance. This was no ordinary courtroom dispute. This was a spark that leaped beyond marble walls. It touched Congress, energized activists, reshaped classrooms, and unsettled the judiciary itself. Jasmine Crockett had not simply won an argument. She had redirected a conversation. Yet, as powerful as the moment was, the consequences were not solely about individuals. They concerned the nation itself. Because this clash compelled America to confront deeper questions. What constitutes the proper judicial role in defending democracy? What occurs when constitutional arguments are dismissed as politics? And who ultimately bears responsibility to remind us that the Constitution belongs not to robes or gavels but to the people? These were not questions for one courtroom alone. These were questions America itself would now need to address. Questions that would shape democracy's very future. When the dust settled from that extraordinary clash, America was left not merely with one case's verdict, but with a mirror held up to itself. The confrontation had become a reflection of the nation's soul, its struggles, and its global standing. For many, it crystallized the profound tension between law as procedure and law as principle. Judge Howell embodied procedure, the guardian of order, precedent, efficiency. To her, the courtroom existed not for grand concepts or historical lessons. It existed to interpret statutes, to eliminate distractions. But Crockett embodied principle. To her, the Constitution represented a living promise forged through struggle, intended to protect the vulnerable from power. When she declared that the Constitution does not conclude at a judge's bench, she articulated what countless citizens felt, that democracy's guardians must do more than enforce regulations. They must protect rights. And across the country, people acknowledged understanding. They grasped this was about something larger. It concerned who determines democracy's meaning. Beyond America's borders, the moment resonated. Foreign newspapers published headlines. International commentators marveled at the spectacle. To allies, it offered a reminder of American resilience. To adversaries, it provided ammunition, evidence of internal divisions. But regardless, the world was watching. And what they observed was not weakness. They saw struggle. They saw a nation wrestling openly, painfully, with its ideals. And in that wrestling, they saw something rare. Democracy alive, imperfect, but unafraid to confront itself. At the core was symbolism. A black woman congresswoman, formerly a grassroots attorney, standing resolute against a white federal judge, a symbol of establishment authority. That image carried weight shaped by centuries of struggle. In Crockett's raised hand, many recognized echoes of Rosa Parks, of Fannie Lou Hamer, of Barbara Jordan. That is why this moment mattered so profoundly. It was not simply Crockett versus Howell. It was past versus present. It was the question every generation must answer. Who will speak when authority oversteps? Who will remind us that the law serves the people, not the reverse? In living rooms and classrooms, the question persisted. Was this the dawn of something new? Was Jasmine Crockett's defiance the spark of a new leadership generation unafraid to challenge entrenched power? Or was it merely a rare flash of courage? Nobody could yet determine, but one thing was certain. The confrontation had left its mark. It had stirred conversations not only about voting rights but about democracy itself. And once such conversations begin, they are not easily silenced. The road ahead beckoned uncertain, perilous, yet filled with possibility. For what would come next was not predetermined. It would be written by the choices we make as a people. History is not created in a single moment. It is created in the echoes that follow, in the choices that ripple outward long after the gavel falls. In the months that followed, federal judges across the country took notice. Judicial training programs began quietly incorporating discussions of temperament and civility. Where a sharp rebuke might once have gone unchallenged, judges now weighed their words more carefully. The Howell incident became a reminder that authority must be balanced with restraint. A robe grants power, certainly, but not infallibility. And as Crockett had made clear, the Constitution binds judges just as surely as it binds legislators. For Jasmine Crockett, the path forward expanded. She became more than a congresswoman. She became a symbol. Invitations flooded in. Her speeches attracted crowds. Her presence reminded America that courage could exist at the intersection of law and politics. Young lawyers wrote seeking mentorship. They saw proof that one could be both fierce and professional, both unyielding and respectful. And her words, "The Constitution does not conclude at your bench," became a rallying cry. The broader voting rights movement surged. Donations soared. Volunteers multiplied. Civil rights organizations integrated her performance into training modules. Mock trials featured the Crockett scenario. Professors lectured on the Crockett approach. This was not about one woman. This was about a movement reclaiming its voice. But let us be clear, the road ahead was not without peril. For every victory, there were setbacks. For every judge who listened with humility, others bristled. The struggle for democracy has never been a straight line. It bends, it stumbles, it rises and falls. Yet in that bend lies possibility. Because as Crockett demonstrated, a single voice, steady, prepared, principled, can redirect the course of debate. It can force even the most powerful to pause. And that is where the road ahead truly lies. Not only in judges' chambers or congressional halls, but in us. For democracy is not defended by titles alone. It is defended by citizens who refuse to be silent, who demand accountability, who remember that the Constitution is a living covenant. Crockett carried that truth into the courtroom. But the question is, will we carry it into our communities, into our towns, into our votes? For democracy's future does not belong to courts or Congress alone. It belongs to the people and the choices they make here and now. And so, we return to that silent courtroom, to the gavel's echo, the fire in Jasmine Crockett's eyes, and the words that rang out like a hymn of defiance. The Constitution does not conclude at your bench. What began as a clash became a parable for our age. It reminded us that democracy is not safe simply because laws are written or institutions stand. Democracy survives only when those entrusted with power are willing to defend it, and when ordinary citizens demand that it be defended. For some, the memory of that day is anger. Anger that a judge could dismiss constitutional arguments as politics. That the rights of millions could be brushed aside. For others, it is sorrow. Sorrow that in the 21st century, we still fight battles echoing those of our parents and grandparents. But above all, it is hope. Hope because Jasmine Crockett stood firm. Hope because her example spread. Hope because she showed that courage and principle, when joined, can bend even the most rigid halls of authority. The lesson is clear. The Constitution does not belong to robes, gavels, or marble walls. It belongs to the people, to all of us willing to defend it. Do you believe Jasmine Crockett's stand represents a new era of leadership, or was it an exception, a rare moment in a fragile system? Remember this: judges may strike their gavels. Politicians may raise their voices. But the true power in America has always rested in the hands of the people. People who believe, as Jasmine Crockett reminded us, that the Constitution does not conclude at any bench.